brother down with Shizzywhiznut.
There's an open letter to the legal pretender who filed a case brief built on sand. Well, there is weak lawyering, and then there's the kind of fantasy pleading you just dumped on the docket. Now, I've seen sovereign citizens with cardboard driver's license make tighter jurisdictional arguments. Well, you aimed at Jeremy's second amended complaint, but instead of addressing what's in it, you wandered into your irrelevant doctrines, waving it at every rest stop along the way like a lost tourist. You kicked off with a personal jurisdiction dodge, as if Florida's can't touch you because you swear you don't have a minimum contacts. Cute, except Jeremy's complaint names the Florida LLC and a Florida resident and alleges you aimed your conduct right at them. That's not a stretch, that's a bullseye. The 11th Circuit has been crystal clear. If you knowingly direct conduct at the forum jurisdiction exists, you can shout, but I'm not in Florida all day. The problem is your actions were. When you try to inflate the service issue into a defense, you whine that the Second Amendment complaint wasn't properly served, like that means it doesn't exist. That's not jurisdictional silver bullet. It's a stalling tactic. Even if there were a glitch in service, the remedy is fixing service, not throwing the lawsuit into the trash. Pretending you get a free pass because you duck the paperwork is less law and more like a playground taunt. You can't see me, na 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 na. Judges don't indulge in that nonsense. Well, from there, you wandered into the boilerplate 12b6 territory, chanting Equably and Twombly like they were holy scripture, but incantations don't move the court. Jeremy pled actual statutory claims. FDUTPA, Lanham Act, tortious interference with factual allegations and specific damages. That's not a threadbare recital, that's called a lawsuit. But you don't erase it by waving the magic words conclusory in bold type. As if the show needed more comedy, you tried to sneak in Florida's anti-slap statute, like it was your own little secret weapon. Well, except this federal court governed by federal rules, anti-slap doesn't override Rule 12 or 56. Might as well have cited rules of monopoly, state procedural statutes that don't trump the federal rules, and every judge in this circuit knows it. That alone would have been bad enough, but you just kept digging. You charged into FDUTPA, puffing about how YouTube donations and rants aren't trade or commerce, except the Second Amendment complaint actually does plead FDUTPA against you, and it ties deceptive conduct to monetized videos, memberships, ad revenue, and donations. That is trade and commerce. You don't get to claim immunity because your storefront is a live stream instead of a strip mall, and congratulations, you argued against yourself and proved the statute applies. Let's talk about the detail. You dragged out the standing cases that focus only on consumers, ignoring that FDUTPA protects competitors as well. You held up those authorities like they were holy writ, while skipping the part where Florida courts already said you can apply to unfair practices that distort competition. Judges notice when you hand them half a statute and hope no one reads the rest, and that's not law, that's just laziness with citations. Then came the Lanham Act. Well, that was a brilliant go fuck. I haven't even got to that yet. You stopped your feet that YouTube videos aren't commercial advertising or promotion. Except the complaint pled exactly that, false and misleading statements in commerce designed to harm your competitor's business. You kept insisting you're not Pepsi buying Super Bowl ads, but nobody said you were. The claim is that you monetize false attacks to divert viewers and sponsors. And that fits. You didn't knock it down, you confirmed you just don't understand the statute. Next, tortious interference. You complained there weren't contracts listed one by one, that lost subscribers isn't specific, except the pleading does point to interference with sponsors, vendors, and business partners. The law doesn't require Jeremy to attach his entire subscriber list as an exhibit. You don't erase a claim by pretending relationships don't exist because they weren't spelled out to your liking, dumbass. That's not legal reasoning. That's hand waving. And of course, the jurisdiction dodge again. You argued you don't have minimum contacts with Florida, as if targeting a Florida LLC and a resident plaintiff with online conduct doesn't count. The 11th Circuit has made it clear. If you deliberately aim at a forum, you're in the forum. You don't get to hurl content at a Florida target and then play, who, me? When the court points to personal jurisdiction, it's not geography that saves you, it's law, and you clearly don't have it or any concept of it. But just when I thought the circus couldn't get any louder, you pulled in the Florida anti-slap statute out of your pocket like it was Thor's hammer. You waved it around, chanting public participation as if the judge would forget we're in federal court. Rule 12 and Rule 56 govern here. Anti-slap doesn't override the federal rules, and the 11th Circuit has said as much. Jamming state anti-slap into federal proceedings is like swiping a bus pass at your gap tooth. Toll booth. Wrong tool, wrong place. It makes you look stupid and ridiculous. Well, and then came the filler, the 9th Circuit puffetry cases. Out of circuit dicta irrelevant citations, you might as well have quoted Canadian fishing regulations. None of it overrides binding 11th Circuit precedent, and all of it read like a desperate page padding. Worst still were your citations themselves. They were orphaned pin sites, typos that turned real parties into imaginary corporations, and half-finished authorities left dangling like karaoke lyrics when the singer forgets the words. You didn't write emotion, you vandalized the docket with a blooper reel. By the time you finished, what you filed wasn't emotion. No. It was a tragic one-act play where you get to try to play all the roles: the lawyer, the victim, confused statutory interpreter, and amateur magician, hoping Iqbal would vanish the complaint. If this weren't a law school exam, you'd get partial credit for effort and a polite note: please stop embarrassing your fucking self. If what you filed wasn't advocacy, it was a scrapbook of boilerplate, misapplied statutes, and irrelevant case law. You didn't rebut FDUTPA. You didn't counter Lanham. You didn't gut tortious interference. You didn't touch defamation, conspiracy, or malicious prosecution. You shouted at shadows and argued that no laws that no one pled. Well, and judges, they're not going to reward that. They're going to toss it aside and move on to the real claims. And here's the brutal truth. Even if every single case name were spelled right and every citation polished to blue book shine, it still wouldn't matter because not one word in your 30-plus pages engaged with the complaint. You were busy shadowboxing while the actual claims, statutory, common law alike, walked right past you untouched. So congratulations, dipshit. You've managed the rare feat of producing a motion that's irrelevant and incompetent at the same time. It just doesn't fail on the merits, it fails on the proofreading. And you're not defending yourself in federal court, you're auditioning for a parody skit on how not to practice law. And unfortunately for you, well, you nailed it. Spot on. I didn't think any other idiot could be as idiotic as ever, but, well, you manage to surprise us with your stupidity every day. Thank you for that. We do appreciate it. It keeps us well entertained. I hope that you make lots of money off of YouTube and you live long and prosper, because I'm going to continue to mock your stupid filings every single day. Signed, the Velcro shoe wearing, short bus riding artard who still managed to understand your own case better than you did, and most definitely owning you all the way.
It is about time. Let's break this mother down. With Shizzywhiznut.